All right, good morning, everyone. My name's Henry Butler. I'm the Dean of Antonin Scalia Law School. Welcome to George Mason University and to the Law School. We're delighted to have you here for the Center for the Study of the Administrative States Conference on Environmental Law in the Administrative State. And we've got a great program put together for you. The academic centers here at the law school really have a big impact on the way we organize things and produce research. This has been a typical week at the law school. We had on Sunday through Wednesday, we had AGs, 40 senior staffers from state AG offices and our economics institutes for them. On Thursday, yesterday, we had a program for the Center for Protection of Intellectual Property dealing with what's called their Edison Fellows, which is a program where we take scholars from other schools around the country and through a series of 4 workshops really train them up on important policy issues in intellectual property. We've also had one of our alums came in this week for a speaker. His name's Steve Mellon. He was the lead prosecutor in the Boston Marathon bombers case. It was one of the most compelling speeches I've ever seen, talking about how he dealt with that. It's been a busy week here. This is an important part of what we're doing, but perhaps more important for me is that yesterday I walked into the lobby of the atrium of the law school, and the Antonin Scalia Law School lettering is up there. So during one of the breaks, walk down the hallway, check that out. We're going to have a formal dedication of the naming on October 6th, and it's going to be a really big deal for the school. I'm really thrilled with the progress that Naomi Ryle has made in developing this center over the past year. And as she will explain to you, we've got a process where we go through where we're funding research, vetting it, and then using it as the backbone for conferences such as this. So welcome. It's great to have you here, and please welcome Naomi Ryle.
Well, thank you all so much for being here today. As Henry mentioned, this center was founded less than a year ago, but we've been busy commissioning papers and hosting conferences. As Justice Scalia once said, administrative law is not for sissies. And it's really in that vein that the center's mission has been to question some of the foundations of the administrative state, to revisit constitutional questions regarding administration, and to re-examine the political and judicial accountability of agencies. And our conference today focuses on environmental law, which in many ways is a lens to consider some broader issues of importance, including standing, federalism, and the problems of informal regulatory actions. And we're really pleased to have with us so many distinguished scholars and practitioners to discuss these issues. As you'll see, the panels are organized around a series of papers that were commissioned for a research roundtable last May. If you're interested in reading those papers, you can find them on our website, which is administrativestate.gmu.edu. Before we begin, I just wanted to say a very heartfelt thanks to Jonathan Adler, who is a professor at Case Western Law School and a senior fellow at the center. He's done most of the hard work in organizing this conference. I also wanted to thank Jeff Smith, Amanda Hu, and Sasha Packer for all of their help in setting up the logistics of this conference, and to my research assistant, Tom Hunt, who, although he's graduated, continues to still help with the center. So thank you all so much for coming to the conference today. I hope to see you at future events. Thanks. And with that, I will turn it over to Elizabeth Price Foley, who is a professor at Florida International University School of Law. Thank you.
Thank you, Naomi. Is this working? Good. Good morning to everyone. Thanks for coming out early in the morning to talk about the exciting topic of standing. That doesn't usually doesn't get most people out of bed, but it got you out of bed, so give yourself a little pat on the back. I'm going to introduce the speakers, and then we're going to do something a little bit different. We've decided sort of amongst ourselves to go on a frolic detour and dispense with the seriatim presentations and instead do sort of more of a freewheeling back and forth of questions among the panelists. So this is sort of an experiment. We'll see how it goes. And I think since there's so few people in the audience, we will maybe if you have a question that is triggered by something that's going on at the panel at that moment, if you want to raise your hand, I'll try to recognize you and fit you into the discussion then rather than waiting till the end. We'll see how that goes, okay? So bear with us. Let me introduce the panelists. To my right is Patrick Ryrick. You can tell when I was in third grade I had problems with my R's and my W's. But he is the Solicitor General of the state of Oklahoma. To his right, Steve Vladeck. He is a professor at the University of Texas School of Law. To his right is Shannon Raisler. She's a professor at the Oklahoma City University School of Law.
I'm surrounded by Oklahoma.
That's true, you are. And to her right is Jonathan Nash. He is a professor at the Emory University School of Law. So I'll just get the discussion started. I thought maybe we would start with big picture stuff and maybe have a freewheeling discussion that's more normative in focus. And specifically, I want to just throw it out to the panel about what should the state's interest be in establishing standing to sue. And in particular, several of you have written things about what is the nature of the sovereignty interest that states should be asserting. I know, Shannon, you wrote a recent paper with a very specific thesis about it. So I'd like to get the panelists' opinion about what constitutes a valid sovereignty interest to establish standing. So Shannon, do you want to start that one off?
Wow. Well, no pressure. Rather than sum up the argument in the paper, maybe I'll start by saying this. For some time in the legal scholarship, and can everybody hear me? That's good. It doesn't reverberate back. The understanding has been that states can rarely litigate what we would call sovereignty interests, right? I think there are early cases where states in the Supreme Court's original jurisdiction bring cases to adjudicate border issues, some things of that nature. But then there are also early cases that suggest that states can't sue the federal government to challenge its authority. And an old case, Massachusetts v. Mellon, is often cited for the proposition that states can't sue the federal government on behalf of their citizens, even in a 10th Amendment sort of challenge, because the federal government is the one who represents the citizens under federal law, right, as the sort of parens patriae authority, the parent of the country in that context. But what we see over the 20th century is that states do, in fact, challenge federal authority, right? Many of you are familiar with challenges like the New York case and others under the spending clause, conditional spending, the notion of what is coercion, the Health Care Act, most recently, right, where states challenged federal authority. So they do, in fact, do this, and I think that the Supreme Court jurisprudence in this area is very muddled, right? That we should actually say that states do sue based on what I think should really be called governance interests rather than sovereignty interests, because it reflects the movement in the 20th century away from a kind of dualism and federalism, and recognizes that states and the federal government often partner together to implement administrative schemes. And certainly in the field of environmental law, this is quite common. While it's often called cooperative federalism, it is sometimes not so cooperative, but nonetheless, the federal scheme contemplates state partnership. Right? The federal government could not do it alone. They are governing together in the implementation and enforcement of things like the Clean Air Act and the Clean Water Act, right? So in Massachusetts v. EPA, when the states challenged EPA's refusal to regulate, to pass a rule regarding greenhouse gas emissions from new motor vehicles, the court, as you all well know, issued a decision that leaves us all sort of scratching our heads, right? So while it's special solicitude for the states, they have standing. Nobody knows what that means, but I think we should recognize that it means that they do indeed have special standing. They have a governance interest in challenging federal authority under schemes where they partner with the federal government to implement and enforce law, right? And I could say more about why I think all of this is confusing and the precedent that leads to that, but that's my general sense of not only where the law has taken us over the course of the 20th and now this century, but also where it should be. So I've already
If I can just follow up for a second, and under this governance approach that you propose, I mean, are you envisioning that this would be the only basis for state standing, or this is just a special sort of category in addition to the traditional, more classically characterized sovereignty interest?
I think it is a more coherent approach to what we might call a sovereignty interest.
Okay.
I can also say more about how I think it aligns with the injury in fact test, which Steve has written about, is even though courts are tinkering with it, it's not likely to go away, right? I mean, it's with us, right? So,
Merrick Garland's going to kill the injury in fact test.
even for states, I mean, I think it might be a good idea to get rid of it in the context of state governance or sovereignty, because it's kind of an imperfect fit, but we don't have to. I mean, the injury in the context of a case like Massachusetts v. EPA is to the state's sovereignty interest, to their governance interest.
But that's not the only injury, right? I mean, and so I think Massachusetts versus EPA might be a good place to start, because I think that is the source of a lot of mischief.
True.
Right? And or from Patrick's perspective, maybe hope.
Opportunity.
An opportunity. Because I think, I mean, you can read Justice Stevens' opinion in two completely different ways. One is the way Shannon just did, which is to look at the discussion of the special solicitude owed to states, which is part of the court's long-standing old jurisprudence about the ability of states to sue parties other than the federal government. That in those contexts, states are owed special solicitude. To incorporate it into the sue in the federal government context is what causes the mischief. But then he goes off on the unique injury Massachusetts suffers as a coastal landowner. Right? So Massachusetts in that regard is different from, if you'll forgive me, Oklahoma. Right, which does not own, I think, any coastal property. So, you know, I don't know that Massachusetts versus EPA is so obviously endorsing a comprehensive dilution of the injury in fact requirement for state standing. I think it's equivocal and unfortunately loose. And I think the better question is not like what kinds of interests states should be allowed to sue on, but why? What is the role that a state can play as a plaintiff vis-a-vis the federal government? So I think it's a very different conversation versus federal plaintiffs than versus other defendants.
Although when you say that, I mean, the what versus the why, I mean, the what is tied to the why.
Maybe.
Right?
I don't. I mean, that's the question. But I think we have to have the why first, right? I mean, so in other words, to me, there's a very different question. The Supreme Court's most recent real discussion of what it calls quasi-sovereign interest is this 1982 case, Snepp versus Puerto Rico, right? Where the court treated Puerto Rico not like an arm of the federal government, and specifically said we're not considering that Puerto Rico is a territory exercising federal powers, and then talked about why it was important for Puerto Rico to be allowed to sue in a state capacity. Right? So the why, I think, has to drive the what, right? Why? What is the role that states can and should play uniquely as plaintiffs, separate from ordinary people?
And you don't think the why can be sovereignty? And the what can be sovereignty?
So I don't know what that means.
I mean, at the same time. Well, I mean, you know, take 10th Amendment issues, take all federalism issues, take New York versus United States.
Right, but so listen, I don't think all federalism issues are created equal, right? So here's the problem. I think there's a big difference between. I think the first healthcare case is a great example, right? Mm-hmm. To me, there's an enormous and critical difference between the injury, let's say, Florida suffers. Mm-hmm. Under the Medicaid expansion, which is to Florida as such, right? It's not to people of Florida. It is to Florida, which after 2019 is on the hook for 10% of the cost of new Medicaid beneficiaries, mm-hmm. Versus the individual mandate, right? Which is an injury to Florida citizens,
correct,
but not to the state, right? And so I actually think the circuits got that one right. I think the 11th Circuit was right to say Florida had standing. I think the 4th Circuit was right to say Virginia did not. Because I don't think sovereignty helps answer the question of which particular kinds of federal claims injure states as such, and which just injure lots of people, and the state feels like it can represent all those people.
And so with that theory in mind, what do you think about the Fifth Circuit's approach in the Texas case?
I'm against it. No, but let me not be coy, right? I mean, my frustration with the Fifth Circuit's approach is the injury it said Texas suffered.
Yeah. Driver's licenses.
Was the driver's licenses. Now, what's important to understand, as a Texan, I can vouch for this, right? Texas voluntarily. God, I just said I'm a Texan.
Wow.
This is a new development for me.
That's right. You're adjusting.
I'm adjusting.
Okay.
Texas subsidizes driver's licenses. Texas voluntarily chooses to provide driver's licenses even to those who don't have lawful immigration status, they have temporary immigration status, right? So part of the problem in the Texas case is that the injury Texas is claiming to suffer, first, is not unique to Texas, and second is one Texas voluntarily inflicted upon itself.
Well, I mean, does anybody have a response on that, Jonathan, about especially voluntariness? I think there's a response. But any of it.
I guess I just wanted to say, and I think you can sort of look at Texas, and what Texas tried to do is sort of in the aftermath of Massachusetts, and they're trying to figure out what exactly they're supposed to or should allege in order to get standing. So I think it's right that Massachusetts left things in a bit of a muddle. I think special solicitude, you could see it, and this is where I think Texas tried to do it both as, you could see special solicitude as sort of allowing states more leeway on alleging a traditional economic injury. So they're sort of saying driver's licenses are going to cost us money. The Fifth Circuit talks about how much money it's going to cost Texas. And then you could also see Massachusetts special solicitude as going to sovereignty, and there also driver's licenses go to the particular sovereign interest of Texas, depending on how you understand that, and the Fifth Circuit talks about that also. So I think Texas, I agree that the opinion is problematic, and what Texas tried to do is problematic, but it's problematic in light of the precedent that came before. I guess I'd also say that I do agree, I think I disagree with Steve, and I agree with Shannon, that there ought to be some kind of sovereignty interest that could motivate standing. So, but I guess where I disagree with Shannon is, I think actually the issue isn't where there's sort of states are working in tandem with the federal government. There's more of a question of preemption that's getting rid of state sovereignty or denying state sovereignty at the same time that the federal government is arguably not filling that void. So,
John, so you think preemption is sufficient to confer standing?
I wouldn't go that far, but I think
Tara Grove does.
No. I'm not going to go that far. I don't think, but I am suggesting that I think that's sort of denying an interest and it also sort of goes to your why in a way, right? It sort of gives you something that the states can assert. There's a question of democratic accountability that's put at issue to the extent that the states aren't able to legislate something that perhaps the citizens expect them to, and the federal government is sort of playing it in the middle. So.
Patrick, you want to give us some real-world perspective?
Yeah, well, I want to chime in on that last point, because I don't think on the preemption question it's a straight yes or no. I think there are two categories that you have there. One, I think the cases where what we're arguing is that an act of Congress preempts what we want to do are quite a bit different than when an executive branch agency is doing something, because I've called that preemption without representation in the latter category. The basic constitutional bargain is states, we give up some of our core sovereign powers, but we participate, or at least our representatives in the Congress participate in the process of creating the laws that preempt our state sovereign prerogatives. And when you have executive agency that as a state you believe is not consistent with what happened in the halls of Congress, I think that's a case of a different quality and kind. And I think in those cases, I think the preemption injury is an injury in fact. In the practical real world sort of examples, I want to tell you, at any one time in Oklahoma, we're probably litigating a dozen environmental cases. Half of those or more will be just sort of your really straightforward, we're suing someone because they've polluted a river, or they've polluted groundwater, et cetera. Those are really non-controversial. That's not what we're talking about here. The others are, we have a handful of cases where, in the typical case, we are suing a federal agency as a result of some sort of rulemaking or agency action that the agency's taken. Now, when do we decide that we're going to sue or not sue? Well, first, someone has to bring it to our attention. So a constituent citizen, someone is going to come to our office and say, this is bad. This is going to be a problem for us. This is going to be a problem for the state. So it gets on my radar. At that point, usually my first step is to take a look at it and say, well, was this a lawful agency action? If so, end of story. If I have some questions and concerns about the lawfulness of the action, it seems to me that the agency might be pushing the law a little bit with respect to what Congress said, then my next step is typically to go to our state agency that would normally be occupying that regulatory space and talk to them. And if they tell me, yeah, we think this is bad, this is not how we want to regulate, this is going to preempt our ability to regulate in the way that we think best for Oklahoma, that's the triggering event. So it's that sequence. I mean, someone has to bring it to our attention as something that's going to be bad for Oklahoma. Then I take a quick look and say, do I think there are legal problems with this executive action? And then lastly, the triggering event is it has preempted our state regulators' ability to regulate in the way they see fit for Oklahoma.
And when you say that, when you do the legal analysis, are you talking about looking to see if there's specific, for example, commandeering or coercion arguments that you can make, or is it broader than that?
I usually start with the straight APA type arguments. Yeah. Is this arbitrary and capricious? Right. Is this, is this the clear statement rule arises a lot in these types of cases involving states because they typically are invading some sort of area of typical or historical state concern.
Patrick, is there any difference from your perspective or from how the case comes through your office between an injury that is quite clearly suffered by Oklahoma uniquely versus an injury where Oklahoma suffers in a way that perhaps many other states would suffer as well?
No, not really, because in so many of these cases we are in fact suing with, in the Clean Power Plan case, 26, 27 other states. So I don't necessarily look for an Oklahoma unique interest. I do normally try to at least arguably have an injury to some state proprietary interest. I try to have some sort of argument, a parents patriae type argument, and then I try to have some sort of sovereignty, government.
That's the problem.
I like to cover the spectrum and give the court a range of options. Right. No, that's true, but we've had no trouble in environmental cases establishing standing. We've not been found we've not been denied standing in any case, environmental case. It's been an issue in the immigration case,
yeah.
And then in another case we had where we challenged some of the Dodd-Frank regulations, it was an issue. Right. Other than that, courts have had no trouble finding state standing in these cases.
No, it's much more common than I think people sort of give it credit for sometimes. But I also wonder, because Steve, you just kind of mentioned something that piqued my interest. Does it really matter, how many states share the sovereign interest? Does it have to be unique to one or two or three states? What difference does it make? It seems to me that that's irrelevant.
But I guess my question is, if it's irrelevant for states, why isn't it irrelevant for all plaintiffs, right? And so this goes back to
because the nature of sovereignty is a harm in and of itself, and it doesn't matter if all 50 states or just one.
Well, but it begs the question, right? Because so this is why preemption as a theory of standing, I think, is so interesting and problematic. Because if basically you're bootstrapping standing onto the merits by saying that if the law is unconstitutional, if the federal law or the federal regulation or the federal action is unlawful, then we ought to be able to sue, even though I'm sure we would all accept that if the federal law is lawful, we may disagree with that analysis, but if the courts say that the federal practice is legal, then the state law is preempted, right? And so tying standing to that kind of sovereignty understanding, that federal laws that do anything to displace state practice or state law is an injury, I think is turning the supremacy clause on its head, right? Because it's saying anytime we don't like what the federal government's doing, right, all we have to do is assert a contrary state practice and we can sue.
So you're worried about the conflation of merits and standing.
Well, no. Let me sort of pull away the clothes. I'm worried about states becoming the first movers in all litigation, right? So Alex Bickel wrote an article in 1966 where he worried about this, right? That if to me, the cost is not one bad case or a series of decisions that don't make sense, or even a merit outcome I disagree with. That's fine. That's small potatoes. The cost to me is, we have standing doctrine for better or for worse, and I actually think mostly for worse. We have standing doctrine to sort of slow the courts down, right? So that the courts are the last movers, so that the courts are conservative. And the more that we're willing to recognize broad, unique state sovereignty-based justifications for standing, the more states are going to be able to challenge federal policies at a speed and at a phase where private plaintiffs won't be able to, right? And I think that's a recipe for gridlock, and I think it's a recipe for putting courts in front of political debates.
Well, can I jump in here? And it's one thing I thought was really interesting in your paper. You quote
the only one, right?
Justice Scalia, the speech he gave at I think Suffolk College, where he talks about the classic role of the states being this counter-majoritarian role. But what I think he was describing there is just sort of the basic idea that courts are there to uphold the Constitution. And we often shorthand refer to the Constitution as a counter-majoritarian document. And that's true with respect to individual rights. The individual rights put in the Constitution are counter-majoritarian rights. But overall, the Constitution openly embraces majority rule. I mean, that is the very structure that it establishes. Democracy is the rule. The counter-majoritarian sort of notions we build into the Constitution are the exceptions to the rule. So what do you do with the cases like this? Because this isn't a case where, as a state, we are challenging what we believe the majority has done by a statute enacted by Congress. We, in fact, think that the executive branch has done something that is quite counter-majoritarian, right? They've gone in and, we think, end-run the will of Congress with respect to an agency action. So that seems to me to be perfectly in the wheelhouse of the judiciary, because that is upholding the Constitution. That is the constitutional structure. Congress makes the laws that preempt state police powers. And if we believe that, again, that the executive branch has done so illegitimately, that seems to me to be exactly what our court should be doing.
So at the risk of using Scalia to respond, I don't know how you reconcile that with Lujan, right? I mean, because the whole sort of crux of his argument in Lujan is that it's not the court's job from an Article II perspective, right, to be the sort of arbiters of the relationship between Congress and the president if you can't find some specific injury to the plaintiff as such, right? And so, I'm not. Don't hear me saying that's not a problem, right? I think there's a real question about how we find the right parties to sue. And Patrick, frankly, I think there's a real issue with the preemptive force of regulations, right, and the number of problems that causes. I just worry about solving that problem with a broad rule of state standing that would allow. I mean, let's all be clear, right? We can all think of federal policies that we have no problem with states challenging because we want the federal policy to go down, right? But that to me is we can all think of them, right? And so different states are going. Vermont's going to be the next state to bring a radical.
Yeah. Well, we're in a particularly tough spot, and again, when we look at one of these issues and it doesn't appear to us that the democratic process can resolve the issue, and some of these, Congress can pass a law, the president's going to veto it, so then what? Then perhaps we have some better evidence to present to a court in litigation, but it appears that litigation is our only option. And so, I think in year one of a presidency and sort of the setup that we've had in the past 8 years is quite a bit different. I've actually passed on cases in the last couple of months because I'm like, well, let's wait until after November. Maybe we don't have to sue right then. I think that's unlikely, but let's wait and see if democracy sorts that out. But we've been in many cases we've really felt like litigation was the only option to resolve the issue.
Jonathan, you want to jump in?
Or do you?
I'm sorry. Yes, sir. Please.
Brian Mannix from GW, and a question for Patrick. I like the distinction you make between preemption by congressional action and administrative action. I wonder if you'd apply, for supremacy clause purposes, a stronger form of the non-delegation doctrine to federal regulation to get to that point.
I mean, I think at this point I'm in the Phil Hamburger school of the entire administrative state is unlawful. So I think the answer to your question is yes, I would. I mean, I think we have all sorts of basic fundamental constitutional problems with the nature of the current administrative state. I'm not going to get into the weeds on that. We will go down a rabbit trail that we don't intend to. But yeah,
and therefore state standing.
Yeah, and therefore state standing. That's exactly right.
Well, it is kind of sad when you have to rely on the judiciary at the end of the day to resolve some of these problems because they cannot be resolved politically.
I wouldn't say they cannot. I mean, they can be resolved politically. It's just our current political climate is one in which Congress doesn't think that it should.
And it's creating a lot of pressure. I mean, there needs to be a pressure valve, and I think that's why a lot of people are rethinking standing and thinking about it in more broad terms than they perhaps in the past.
So this is my question to my colleagues. Are we rethinking standing? I mean, has there actually been pressure to let private plaintiffs sue in ways that they couldn't previously? Or is it just like there's this pressure, so we don't really want to turn standing on its head, so let's just let states sue and that will solve the problem?
Well, I'll be politically incorrect here for a moment, but I don't hear a hue and cry necessarily for individuals to have access to the court. I think standing is relatively available for people who show some modicum of concrete personal injury, but the states are in a much tougher bind because a lot of times the interests that they are trying to protect, these structural vertical separation of powers kinds of issues, there's nobody else to do it. There are no private plaintiffs available.
No, wait, pause. I understand, but I think we're conflating two problems. The first is the vertical problem,
Right.
which is the federal government trampling on unique sovereign state prerogatives?
Right.
What Patrick's describing is, I think, a different problem, which is when a breakdown in the horizontal separation of powers at the federal level indirectly produces consequences for the states. I don't think those are
That's
the
a
same
problem
thing.
too. I mean, there's problems horizontally and vertically. It's not, the whole constitutional architecture has some cracks in it.
I'm
right?
sorry, Jonathan.
So, I agree that in some ways the horizontal is bleeding over to the vertical, but that's also the problem you were talking about, sort of the idea that Bickle and sort of states are going to find their voice at the horizontal, at the federal level, and I think that's been problematic. We can debate sort of who's at fault. Maybe everybody's at fault. And in fact, Congress has itself turned to try to get standing in particular cases, right? Because they're not able to sort of achieve things through the political process. So I sort of think at some point, at least if you don't think, and I've written about congressional standing, but if you don't think Congress ought to have standing, and if it can't be resolved politically, then the states are not getting the relief that you might think they were supposed to get in the political process, and that's sort of an additional reason to have state standing. And I guess, yeah, anyway.
So, Jonathan, do you think House versus Burwell is right?
I think that it is...
On standing?
I don't want to agree with the opinions, but I do think that there is a basis for standing. Yes, I'm not sure that the court sort of got it precisely right, but yeah.
Now, I have to jump in here because I was intimately involved in the development of that lawsuit. But yeah, I mean, I agree. I read your paper, Steve, and I agree with you that Collier makes an artificial bifurcation, right, between sort of statutory screw-ups, if you will, by the executive versus constitutional ones. I don't think that's the question. I don't think that bifurcation can stand on appeal. But I think based on not only precedent, but just logic, the House of Representatives and/or the Senate and/or Congress, if both chambers want to join, have institutional interests that can sometimes only be protected by themselves and are palpable and concrete to it as an institution, sufficient to establish standing. I mean, this was a classic case. I mean, whether you take the employer mandate, which will end up being moot, is already moot basically, or the appropriations issue, there was no one else who had standing to litigate those issues. So whether the harm is characterized as statutory or constitutional, they're both palpable institutional harms.
But can I just ask, are we comfortable with the no one else has standing, therefore someone has to? Because, you know, the Supreme Court's rejected that exact argument, right, in the context of modern Establishment Clause challenges, in the context of a taxpayer standing to allegedly unlawful expenditures by the CIA of money, right? I mean, so it seems like there are deep fundamental premises of standing doctrine that are being put into tension by these contemporary, I mean, that's why I wrote my paper, right? I wrote my paper because it seems like we actually are at an interesting turning point. You know, not caused by Justice Scalia's death, but sort of, that becomes that much more interesting now that this is very much in the balance, where basic principles that have governed standing jurisprudence since the 1960s are being sort of recalibrated because of this belief that non-judicial remedies have broken down, right? I certainly agree that non-judicial remedies have broken down. The question is, are we really fully up to accepting the consequences of the recalibration of standing we're proposing to account for the breakdown of the non-judicial remedies?
Well, but Steve, just very
Sure,
quickly,
absolutely.
I think there's a difference between saying that no one else has standing and that sort of gives standing. I agree, the court has rejected that. But there is a sense in which, in some of the cases talking about congressional standing, talk about the idea that the injury is more real because there's no other way to resolve the injury. So I agree with you. I don't think the fact that no one else has standing should give state standing. But if, in fact, you look at the political process and there's a reason that the injury can't be solved the way it traditionally has, that sort of adds to the actual injury that has been asserted. So just to clarify.
Shannon, you had? Okay.
There's a question. Do we want to take this first?
Yes, please.
Hi. So I wanted to, this might get into a conversation right now, maybe not. Thank you, Caroline. But I wanted to go back to something that Patrick mentioned, just in passing, that it was much easier for you to set up environmental standing And obviously that has to do with some of the case law that we have on environmental standing. So I wanted to sort of highlight that for a second and just ask the panel, whoever wants to answer, do you think that it's something inherent about environmental law that makes it easier to show an injury? Or do you think that this is something that's occurred because of something about environmental regulation generally? And then I guess depending on how you feel about that, I'm wondering if this is something that that is part of some kind of movement.
I'll start with a really non-interesting answer first, which is that in a lot of these cases, we also have industry plaintiffs involved, and so often the courts just aren't really taking a close look at the state standing. That may be why we haven't had these issues come up. So I'll throw that out there first and then let y'all get into the more theoretical answers as to why it might matter in environmental law. I do think that these cases to me always seem fairly easy for the state to identify a proprietary interest, a parents patriae interest, and some sort of sovereign interest, whether it be a vertical separation of powers, some sort of preemption issue. I mean, we've never had problems, I think, drafting a complaint where we feel like we've covered those three bases. So
this actually ties in, I think, to what I have a couple things I want to respond to. I think that it could be that it's easier in environmental cases for reasons I mentioned earlier, and that is that federal and state government they overlap in the implementation and enforcement of environmental law. And environmental law is full of citizen suit provisions that also include states, right, contemplate states suing. So that has been less controversial until Massachusetts v. EPA, when everybody was looking for an injury in fact in the unique context of climate change, right? So maybe, is it okay if I shift to, there's been a lot of discussion about line drawing, right, in the healthcare case versus the Texas immigration case. And I actually come down where I think states should have had standing to challenge the Affordable Care Act, and Texas should not have standing to challenge the executive's immigration policies. And so, in other words, preemption isn't enough, right? And if you focus on this notion of injury to a sovereign interest in an age, in an era of shared federal-state governance, right, in the modern regulatory state, in the case of immigration, the state is not engaging in fact, look at the Arizona case, which, by the way, the federal government had standing to litigate its own sovereignty interests, right, when Arizona tried to pass laws that interfered with, according to the federal government, their immigration policy. The federal government really occupies that field, right? There's not a sense of shared implementation and enforcement. So Texas is left under the injury in fact test, looking for some kind of economic injury. And pairing it with, I mean, there's some great dicta, right, from this Puerto Rico case about sovereignty interests including the state's right to make and enforce their own legal codes. Well, if you interpret that, I mean, broadly, that sounds like preemption is enough, right? You can make an argument based on that language, but I think if you read the case law critically, what the court's probably talking about there is the notion that states all the time defend, right, their own laws in court when challenged on constitutional bases, right? It's not clear what that language means, but it gets used in the Texas cases. And so it does seem like we're approaching something like preemption is enough, but I don't think, I think we can draw meaningful lines, right, so that we don't end up there. But that it's clear in cases like the Affordable Care Act, where states are definitely have to share in a governance role with the federal government, and they are going to have to make decisions now about how to go about doing that, that is, for all kinds of reasons, worth giving states standing to sue. And I just add that sometimes these issues get conflated with other threshold issues. I think we can embrace a broader notion of standing and what a case or controversy is under Article 3, and that might still leave us with questions about statutory subject matter jurisdiction, whether a state has stated a cause of action. And it's important to separate this out, right? Because state standing is the constitutional baseline, right? So it may mean that the lines get drawn or can get drawn in other places. So I can say more about that, but I just wanted to throw that out there.
Just to amplify that point, it does matter that the Clean Air Act and the Clean Water Act are explicitly cooperative federalism statutes. And the INS, in the immigration context, is a field preemption statute. I think that absolutely matters.
I agree, and I actually think that's the answer to the question. I think the reason why, so I think there are two reasons why. I think the first is what Patrick just said, that there are much clearer arguments, even if we still might fight at the margins, about the injury to states in a cooperative federalism scheme than in a top-down, we're going to do this state stay out like immigration scheme. That's part of why I find the Texas argument so weak in the immigration case. I also think there is just so much more attention paid, not by trial judges, but by the courts of appeals and the Supreme Court, to standing in environmental cases because it was such a linchpin of the pushback in the 1980s against the broader standing jurisprudence of the Warren and early Burger Court. I mean, it's not even the Burger Court, it's the DC Circuit in the 1970s. So if you read then Judge Scalia's speech, which I talk about in my article, his real target is not the Supreme Court. His real target is the 1970s DC Circuit. And the mischief he saw in those cases was primarily in environmental and some other administrative cases. So I think it's both of those things at once that makes environmental law an a special target of these analyses. For better or for worse, right? I mean, I think we can disagree about that.
You know, and a related point, it came up earlier, the notion that might states have standing when individuals don't. Environmental law is a good example of when that might happen, right? You think about Massachusetts v. EPA, it ended up being easier for the state plaintiffs than it would an individual, because when injuries are diffuse and widely shared, and when you, especially with the causation link in the injury effect three-part test, right? The need for a causal link and redressability, these kinds of widespread environmental harms present challenges for individual plaintiffs, and that's why so much of standing law is environmental.
Well, look at Earth
right?
Island Institute. You know, that case, that was a Scalia opinion, wasn't it?
It was,
I think so.
although there's also a Kennedy concurrence.
Okay. But, you know, I mean, environmental cases, I just think they're just sort of the wild, wild west of standing. I mean, it's pushing the envelope. And that Earth Island Institute case, I mean, the reason they didn't have standing was just because they didn't dot their I's and cross their T's enough on the affidavits, you know, to allege aesthetic injury or an actual intent to visit that particular part of federal land.
But at the risk of comparing environmental, of sort of countermanding my own answer. Is environmental law really unique, though, right? I mean, so consider NSA surveillance.
Shouldn't be.
No, I mean, consider NSA surveillance, right? What is the harm caused by NSA surveillance? It is I mean, if you actually sort of walk through the surveillance authorities that the government now has, especially under the 2008 Bias Amendments Act, it is not that different from the kind of diffuse, broadly shared harm.
Yeah, but there's a different. I think you're talking about the Klayman case, right? The D.C. Circuit.
No, I was talking about Clapper, but
yeah. Okay. Well, I mean, I mean, I'm thinking with the metadata case. Was that the Klayman case? I think it was.
Klayman's metadata. Clapper is 702.
Yeah, 702. The metadata case. You don't have an issue with that holding, do you? Or
sure.
Why? But I mean, because well, I mean, hey, I don't like spying any more than anybody else, but you know, there was absolutely no showing that his particular metadata.
The government testified before Congress that in order for the metadata program to be effective, it had to collect everyone's metadata, right? It was a necessary feature of the program that the government was collecting metadata in bulk. I'm not sure how.
They were definitely collecting it in bulk, but and I'm not sure they had every carrier. I mean, first of all, it was just cell carriers, and it wasn't all cell
They
carriers.
had Verizon, and Clayman was a Verizon subscriber. And so Clayman says the government has testified publicly that it collects all metadata from Verizon. I'm not, my point is, why are we so skeptical, right, in that context, where the government has said publicly we're collecting all Verizon customers' metadata, and Clayman says, I am a Verizon customer, versus in the environmental context, right? That it's the same argument to me. It is, I am harmed because I am one of this huge class of people. The government hasn't singled me out, right? Like this is not a sort of, class of one case, but I am harmed because I have a pretty good claim that I am one of the millions of people who the government has harmed here, right? So my exasperation, just to not put too fine a point on it, is that we're like, oh, in the environmental context, yes, Massachusetts or Texas or Oklahoma, go sue on behalf of everybody. In the Clayman case, where it's a Fourth Amendment claim, what I would have thought was the classical counter-majoritarian, we need the courts, they're like, we're not really sure it's you, right? That to me is the sort of inconsistency here that I think is what puts so much tension on the notion that standing doctrine is coherent as opposed to just a shell for imposing policy preferences.
Well, that's why I wonder, is it really inconsistent? Because go back to Earth Island Institute again, they had the burden of proof and persuasion on the issue of actually having suffered that concrete particularized injury, and if they didn't have their affidavits, all their little affidavits like ducks in a row, and didn't say exactly the right thing, they got kicked out of court. That was the end result of the case. And,
sure.
and it seems like to me the same thing happened to Clayman.
So I guess in Clayman the issue is not ducks in a row. I think no one in the district court or the D.C. Circuit said the problem in Clayman is that he didn't allege specifically enough. What they said was that we're just not convinced, right, that that in collecting all of the Verizon customers' metadata, they also collected yours. And it's that kind of sort of skepticism in that context that I think is what gives standing doctrine a bad name, right? That in one context it's like, oh yeah, just allege that one day you're going to go to that national park, right? Versus this has already happened, but you can't sue.
Well, isn't there also a distinction in Earth Island that the federal agency hadn't acted yet, right? There's this.
Well, some of them were mooted out, I know that. Yeah, because there were settlements.
There were settlements. So
yeah.
Where they had acted, it was settled, and then there wasn't another action.
I think
for the one show eminent harm
tract of land that was still sort of active, that's where they had the affidavit problem with the particularization.
Jonathan wants to yell at me.
I don't want to yell at you, Steve, but I have a comment and a question which prompted by this. The comment is, I think it's fair to say that in the D.C. Circuit, you might have right now, or in recent years, have had the opposite problem that you had in the 1970s. That is, instead of just giving everybody standing, almost knee-jerk denial. So there's the what I think curious standing holding in, I heard what it was called below, but in the UARG case, the D.C. Circuit kind of goes out of its way to say, oh, no standing to challenge these regulations, and the Supreme Court doesn't even think that issue is even really worth any time. When it gets the case. So that may be a problem in the sense that the D.C. Circuit's not actually thinking about what the doctrine actually is. It's just saying, if it's tough, assume no standing. But on the issue of comparing, say, the surveillance cases to the environmental cases and generalized grievances, it seems to me that what we have said in the doctrine in the environmental cases is, if it's generalized, voluntarily engage in conduct that makes it particular, right? Joyce Kelly, go buy a plane ticket. Earth Island folks, make very clear, perhaps expend money that is now lost to connect yourself to the particular federal lands in question. When I think of it that way, I don't understand why the quote-unquote voluntariness of Texas's action in the immigration case matters at all. Because it seems in all these cases, the way we distinguish generalized grievances from those that are particularized is forcing someone to put their money where their mouth is, or to put their money where their subjective value preferences are. And if that, according to Justice Kennedy, would have worked for Amy Skilbred and Joyce Kelly and Lujan, why doesn't that work for Texas in the immigration context, particularly if Texas is doing something that all states do, administer driver's license programs, as opposed to perhaps what Virginia tried to do in the healthcare case, which is come up with a law that actually served no purpose whatsoever other than to challenge a federal statute. I mean, it seems there that's a line that makes sense. But this voluntary, involuntary line, I think if we push on it, actually guts a lot of environmental standing, and in a way that I don't think a majority of the court has been ever willing to do.
I'd like to stand in defense of Texas having standing, because we were a plaintiff in that case as well, and I was involved a lot in the development of those theories. You're absolutely right, Professor Adler. I think it is, to me, a pretty easy case. As a state, well, let me start with the baseline. The court has never really struggled with the idea that border states are harmed when the federal government sort of fails to, it suffers sort of proprietary and monetary damage to their proprietary and monetary interests. I mean, there's a lot of talk even in Arizona about
I was going to
Arizona
say,
and
isn't
Texas.
Arizona that?
Yeah, I mean, it's sort of bearing the brunt of the influx of illegal immigration, but saying, well, you can't do anything about it. So we started with a baseline of, we think the court will accept the premise that this sort of thing can damage or impair our proprietary interest. So what do we want to highlight? And there are a range of, as states, we provide all sorts of things to our citizens voluntarily. I mean, there's public education. I mean, there's a long list. So we provide certain things to our citizens. We choose to do it as a matter of state law. It costs us money. And then the federal government comes in and says, you have to expand the class of people to whom you offer that free thing to that cost you as a state money. How are we not harmed? Either we're going to spend more money, or the choice that we've made that we think it's in the best interest of all our citizens to provide that service, but we would like to exclude a particular class. We have to exclude everyone. We have to withdraw the program.
Well, and
to me, that I thought it was a winner. It turned out to be a winner, I think, unless they rehear the case and decide on standing grounds, which I don't think they'll do. But I don't know.
Does Oklahoma charge its citizens for their driver's licenses?
Yes.
Okay.
But we incur costs like Texas. I mean,
they're subsidized heavily.
There is a cost that we incur every time we issue a driver's license.
That is that you choose to absorb as opposed to pass it on to the customer.
Yes.
Okay.
Right, but they made that choice prior to the federal government's choice, unlike Virginia in the NFIB situation, the ACA situation, which passed that law ex post, after the passage.
But why is the timing
of the act.
relevant?
I think it matters because of this. If I'm a state, if I'm in Patrick's position, I say to myself, okay, you're arguing to me that this is a voluntary injury and therefore it just doesn't count for standing purposes. But from the sovereign's perspective, from the state's perspective, it's like, okay, so the only way I can avoid this injury that I already have the day you take your action as the federal government, because my law is before your law, it's pre-existing, is that I avoid the injury by repealing my law, and that's not a sovereign harm?
We have to eliminate the program that we as a sovereign, in the exercise of our police power, implemented because we thought it was a good idea for our citizens.
Right.
But I guess
so your only choice to avoid that injury is to repeal your statute. That seems like a sovereign harm.
So that's not true, first of all. Let's just be clear, right? You have other options than repealing the law, right? You can just change the program. There's no federal requirement that the state provide driver's licenses to people.
Repeal or amend. We have to do one of the two. Right. Either way, we're changing our law.
Does Oklahoma law not specify what your immigration status has to be to obtain a driver's license currently?
It does.
Right. Does it include those who would have been covered by President Obama's memo?
Yes. And the federal government told us that if we denied this class, they would sue us. Well, there was that extraordinary moment at the oral argument in particular where I think it was the attorney for the interveners, the John and Jane Doe attorneys, when he got asked that question specifically by one of the conservative justices, and he says, yeah, we'd sue Texas if they tried to deny one of these.
Yeah, that was not the best thing the federal government said.
Well, no, I think I may have seemed really kick him in the leg when I said that. But, I think even in the briefs in the case, the federal government, they were careful to not explicitly say they would sue, but not deny.
So, Patrick, here's my question though, right? So, if Texas and the other states have standing in the context of that case, can you think of a context where there's a new regulation, right, in the immigration context that expands or contracts the class of individuals who are lawfully entitled to be in the United States, or analogous context where a state wouldn't have standing to sue the second that rule was promulgated? Because my concern is where's the stopping point? And maybe the answer is there isn't one, But if there isn't one, then that's a pretty remarkable development in standing doctrine, because it suggests that now every single time the federal government changes a policy, it's going to be which state is first to the courthouse. And that's not historically how we thought about standing doctrine.
Is it really that remarkable, though? Because, think about, until, frankly, post-New Deal, the federal government was sort of a non-entity in terms of its relationship vis-a-vis the states. It's become more and more aggressive.
What about after the Civil War?
And shouldn't standing doctrine evolve in that sense? Because, I always have these sort of fun little arguments with my students in con law about, just the derivation of this doctrine itself. It comes from two little words in Article 3, Section 2, case and controversy, or controversies. And from those two little words, they've created this elaborate doctrine. It's like a labyrinth. It's not just standing. It's it's ripeness, it's mootness. There's a lot of things that they're just sort of making up out of whole cloth. So it seems to me, at least if you're an originalist like I am, there's a lot of wiggle room here for development of doctrine.
So you think the case and controversy requirement doesn't actually impose any constraints on the courts?
I think that there is a good interpretation of those words that suggest that there has to be an active controversy, because the word is controversy, between the litigants before you, which means you do have to have them in adverse postures to each other. But beyond that, I think it's kind of open for debate.
Well, listen, I think that's a defensible argument, but I think that would radically change the structure of the United States government. Right? It would basically mean that we don't really need to have legislation, that we don't really need to have political debates, because everything could go right to court. I don't know the universe where that's a healthy system, and I think that's only, maybe we're comfortable with expanding judicial power in that context in an age where we don't like the executive branch or we don't like the federal government. But I'm not sure that if we take a longer view, in the long term, it's a healthy thing to say, yes, the first way to solve all of our political problems is litigation.
But what if I subdivided that class down to what I did earlier, where it's the instances where it is executive branch agency action that is the problem? Because at that point, it's just a check on the administrative state.
And here's the problem.
Surely
right?
that's a good thing.
So here, listen. I'm the last person who's going to say that we shouldn't have checks on the administrative state. The problem is that for the moment, for better or for worse, right, the Supreme Court treats agency regulations as functionally equivalent to federal law, right? Maybe that's the problem, right? Maybe the real issue here is, cases like Fidelity versus De La Cuesta, and the underlying linchpin of contemporary administrative law, that agency regulations have the force of federal law. But that's the thing we should be pushing at if that's the problem, right? And not, and that's, so I really think that's a great argument, but then your real target, right, is that body of case law, which is not about standing, right? It's about the equivalency of federal regulation and federal statutes. And that's a fight we should have.
Jonathan, and
so
then
don't try
Shannon.
to check the administrative state. Let's just go ahead and try to destroy it.
No. Listen, Patrick, if your argument, as I understand it, and please correct me if I don't mean to misstate it. If your argument is that you as a state solicitor general, right, believe that there is a different set of issues that arise from when agency regulations are directed at you than acts of Congress on their own terms, then that says to me that the problem is not standing. The problem is the fact that contemporary law treats those two things as the same, right? And that's I think that's a real problem, and I've written that. I actually think, wholly unrelated to standing, the fact that agencies have the power to preempt state law expressly without replacing it with any federal law, based on implicit delegations and statutes, right, is a huge issue.
I agree with you completely.
But then that's the problem.
That is a more audacious attack on sort of the fundamental underpinnings of
the
it.
So, and I guess what I'm saying is, I actually don't think that's true. I think that is a more direct attack, right? But I think completely reconfiguring standing doctrine is, in the long term, much more audacious because of the collateral consequences it will have.
But you're making a 60,000-foot argument, though. We're in the ideal world, how do we resolve this problem? But I think a lot of this is being driven by pragmatic considerations. It's sort of all hands on deck. Let's just attack this problem of the growth of the administrative state in every way that we possibly can. And standing just happens to be one of them. But
then it's death by 1,000 cuts, right? And it seems to me that, Patrick, I think this is like, if Patrick is right that is the real problem, right? And if other states feel the same way, that the real thing that they're pushing against is being interfered with by regulations as compared to statutes, right? Then I don't think it's that wrong to say, then let's talk about that as the problem, as opposed to let's expand standing so that we can pick off the individual regulations.
Yeah, but
that
to say
particular
expanding
states don't
standing
like.
is kind of, I mean, it's a little bit not correct. I mean, the standing for states
You
has
think
been broad
standing
and...
standing doctrine today is exactly the same as it was 10 years ago?
No, I don't think the standing doctrine is the same as it was 10 minutes ago. I mean, in across cases, I mean, I think it's a very sort of incoherent doctrine, to be honest with you.
But the trend line, I think, is up.
Is it up? Okay, well, Jonathan, you've been waiting to jump in.
I guess as Steve had said before that I was going to yell at him. Actually, I'm going to agree with you, I think, on a lot of stuff. So I want to be clear.
That's
I don't think that we ought to be jettisoning standing doctrine and the tripartite test. I think that does raise a lot of concerns. I like to think what I try to do is to think of ways or sort of thinking about things that are consistent with prior precedent. So whether that's sort of this preemption idea as a sovereignty interest. Another thing you were talking about that I think we agree on is sort of this, or could agree on, this idea of sort of standing's expected value, right? That you might think about particular plaintiffs and whether they're likely to have a harm, and they may not have to show it precisely. And it did seem to me, in Clapper especially, that the plaintiffs actually did kind of make the case we had expended money and all this stuff, and it was actually pretty clear. I think the security cases really come out the way that they do because of the fact that there are security cases. Agreed. And maybe the court should be more honest about that and just say that. It would help. That might lead to more fragmentation in standing doctrine, but I think you could kind of respect that more than trying to pigeonhole everything into a single test. So I don't have a problem with sort of having different measures of injury in particular cases. I don't think we should get rid of the injury idea. I do think we could do more about if there are problems with the growing burgeoning administrative state, and especially perhaps disagreement, the executive branch sort of doing things that maybe go beyond what Congress contemplated. You might be able to get some of that in under existing standing doctrine. So,
yeah. So I just want to agree. I don't know that talking about expanding, or I would question the assumption that we've expanded state standing in any way. I mean, we're talking about, I think we don't quite have it ironed out, the different bases for state standing. And I think one way we can address the concern, if we do open, if we say states do in fact have this special solicitude, and this is how it fits into the injury in fact test, and even if we go the route of an injury to the ability to make and enforce a legal code, which is essentially preemption, right? There is an argument that Congress can still limit the state's access to courts. So to the extent we're concerned with making sure the majoritarian aspect of lawmaking is honored. I mean, it's actually not very widely explored. There might be some constitutional limits to completely cutting it off, right? Like with the Affordable Care Act, the federal government could say states can't challenge this after X amount of time, right? Or can't challenge it at all, and maybe they'd try because perhaps this is unconstitutional. But I think this is sort of untested waters to make the constitutional baseline, you say with just 2 words, really, to build all this doctrine around it is sort of problematic, right? Maybe it's about whether states in fact have a statutory cause of action, right? Congress can step in, or jurisdiction, right? It's interesting in some of the older cases, like the New York case, nobody talks about whether there's subject matter jurisdiction to seek a declaratory judgment, right? And that's actually not clear whether states have that, or whether courts have that subject matter jurisdiction under federal law. So it could be helpful, perhaps, to say that we're fighting these issues in the wrong sort of doctrinal box, and it might force a conversation in Congress, which perhaps is the institution many of us think, should really resolve the question.
Should do something.
Something.
I don't even hear. I just mean like just should do something.
Yeah.
They don't even want to enforce their own subpoenas these days.
No, but I mean, forget that. I mean, listen. it's worth, I mean, Patrick put his finger on something very important. I think it's worth asking, what is provoking us, right? What is putting the pressure on, I mean, whether you want to, you know, whether we think that standing doctrine has evolved, expanded, eroded, just whatever, right? It's clear that there is some interesting stuff happening. And the question is why. So I think Patrick put his finger on one of the pressure points, which is this growing belief that the administrative state is, you know, not being adequately checked by existing mechanisms, right? I think part of the problem is also that the existing mechanisms have stopped working in lots of other ways, right? The question is the solution to that, you know, to recognize standing where we might not have previously? Or is the solution to that to figure out, you know, how to solve the problem more directly? And, you know, my concern, I know I'm sounding like I'm beating a dead horse here, but, you know, if using standing doctrine to solve this problem, first, opens up the door to lots of lawsuits that maybe we previously would have been uncomfortable with, and second, doesn't necessarily solve the problem, right? I mean, if the Supreme Court had taken the Texas case and had said, yeah, you know what, President Obama, this particular act, you know, probably should have gone through the APA, that wouldn't have solved your problem, right? I mean, it wouldn't have actually gotten to the heart of the broader constitutional issue, right? So, you know, I think it's weird to sort of have this fight on these terms as a proxy for what I think are much more important, much more significant controversies.
Well, you know, and I'll just also say, I mean, just in response to that, Steve, you know, your paper, for example, is sort of exploration of Scalia's vision of standing. And as much as I respect Justice Scalia on a lot of things, he also got some stuff wrong. Let's face it. I mean, for example, you know, Chevron deference. You know, I've been told, I don't have any way of confirming it, that he was sort of rethinking that in the last couple of years, and that you know, that's one of his legacies, but it turned out maybe ex post after a little experience to be a mistake. And I wonder if he'd stayed around a little bit longer, that he might have eventually sort of come around and modified some of his more ardent views on standing as well. I mean, we all evolve, right? So, I mean, just because Justice Scalia said it so doesn't make it so. As smart as he was.
That's not my argument. I mean,
no, I know that, but I'm just saying, I mean, but you do start from sort of his justification for various limitations on standing and sort of work from there. And
as sort of a proxy for, is there a way to have an objectively describable understanding of why we have standing doctrine? And maybe the answer is no. Thank you, everybody. Enjoy the rest of the day, right? And that's fine, right? I think Justice Scalia, for better or for worse, thought that there was a way to do it. We may not agree with how he did it. We may not agree with how he even applied it, right? And that's fine. But my point is that, like, if we're going to the point where we say this project to try to create a coherent, consistent, objective body of standing doctrine is just a fool's errand, then we should all just admit that. Including, Jonathan, right, the justices, right? If the problem in Clapper is not the standing doctrine, but the court's reluctance to reach into secret foreign intelligence surveillance programs, fine, say so, right? To me, it's the fiction that this is this, easily applied, easily teachable, right, 3-part test that's doing all this work. It's not.
So we'll get the political question doctrine.
yeah, I was supposed to say there are a lot of doctrines that sort of do that. They're kind of like, you know, smoke and mirrors for something else that's going on sub rosa. I mean, that happens in the law a lot, frankly. So the fact that standing sometimes plays that role, you know, doesn't really shock me.
But then let's admit that when Patrick and his colleagues sue the federal government, it's not because they have a particularly coherent view of standing. It's because we just don't care.
No,
I mean,
it's not
fine.
that. I mean, I actually do think, you know, that you don't open the doors. It doesn't become a floodgate scenario if you recognize that there are state sovereign interests, and then we can kind of work from there as to what those sovereign interests might be. But we do have a lot of case law that suggests this is sort of a sovereign interest. This is sort of a quasi-sovereign interest. I don't think there's any difference.
So
between the two,
when you say, I mean, listen, when you say we have a lot of case law, I'm not sure what you're talking about. Because
well, read Shannon's piece, for example.
I have read
She
Shannon's
goes through them
piece.
rather laboriously.
Yes, but the cases, but guys, hold on a second. Let's not conflate things, right? When Shannon talks about the Puerto Rico case was not against the federal government, right? I think there are different questions going on. We're talking about a state's power to sue other states, a state's power to sue private defendants, and a state's power to sue the federal government. There are just not that many cases where the Supreme Court has allowed states to sue the federal government where it wasn't because the claim was that the federal government had trampled on the state's particular constitutional interest as such. New York versus the United States is a great example, right? The low-level radioactive waste case. In that case, of course, New York is the injured party as such, because New York is the party being forced to take title to the radioactive waste under the provision of the statute, right? Not some private company, right? Those cases to me are not emblematic of a broader pattern in which we've generally allowed states to sue the federal government to, for broad injuries suffered by lots of people.
Well, what makes that any different from the Texas case, where Texas has been injured by a direct action of the federal
So I
government,
think,
been
listen,
forced
I
to
think
spend
that,
money that it
as
otherwise
I've
wouldn't
said, I
spend?
think the Texas case is a close one, right? But my point is just to say that, like, let's not tell a story where the notion that states sue the federal government anytime the federal government does something that imposes any kind of administrative cost on the state is a well-settled, deeply ingrained, long-standing precedent in federal courts jurisprudence. It's not, and maybe it ought to be. But let's tell the story the way it is.
And it isn't clear that it should be. I mean, I agree with Steve. I think that we should be aware generally of the costs of jettisoning or greatly expanding the court's jurisdiction, both in terms of what it would do to a floodgate of litigation, but also the nature of the judiciary and the perception that folks have of the judiciary and should have of the judiciary as resolving actual cases. I think maybe that is the right way to go at the end of the day, but I think there are a lot of costs associated with it that we really need to think about carefully.
And I'd like to, just while we have Patrick here, talk a little bit about the Oklahoma-Nebraska case against Colorado. While we have you. Yeah. Supreme Court decided not to.
By the way, that was my Fed Court's final exam last year.
Oh, was it really?
Thank you very much.
I mean, that's sort of a classic externalities kind of case, right? For people who aren't familiar with it, maybe you could describe what you're suing Colorado over?
Yeah, and we tried to, it fits here because we tried to map a lot of sort of interstate nuisance type ideas.
A lot of old case law.
Yeah, onto the lawsuit. But yeah, the basic idea there is, Colorado has become sort of the wild, wild west of marijuana legalization. And we started getting, again, this is one of those instances these things come about because our phone starts to ring, our local DAs
Sheriffs.
out in the western part, the sheriffs are saying, man, my jail costs have tripled this year, and just based on marijuana interdictions, et cetera, are we going to do something about this? And so we took a look. It seems to me that what Colorado has done is clearly in violation of federal law. Clearly violates the Controlled Substances Act. The federal government has just said, well, we're not going to do anything about it. Although the federal government has been very careful to say we reserve the right to take action against Colorado to shut this down.
Right.
Colorado now, in the latest brief they filed, take the extraordinary position, I think, that not even the federal government can bring a preemption action against them to say that their state law scheme is preempted by the Controlled Substances Act.
Yeah, that's just wrong.
And that the federal government's only recourse.
I think we can all agree on one thing, right? That's wrong.
Yeah, it's sort of piecemeal.
I don't even articulate that. I'm just curious. I mean,
just start prosecuting our citizens. And that's sort of the mechanism that the CSA creates. They say that there just is no right of action for anyone to bring preemption action under the Controlled Substances.
So I actually think that's right. But I don't think that applies to the federal government.
Well, I think Colorado disagrees.
I know.
But the case essentially is, what do you do? And again, this goes back to sort of the constitutional bargain ideas that we've struck. I mean, we agreed to cede our sort of police power over this certain thing to the federal government, and the federal government through Congress enacted the Controlled Substances Act, which Colorado's representatives unanimously voted in favor of. We all agreed this is the deal. These drugs are illegal. And then merely because the executive branch goes and tells a state, we're going to turn a blind eye, if you want to violate the federal law, you can, and the state does that, and it does so in a way that harms our proprietary interest.
Then why not sue the federal government?
We thought about it.
And is there anything you're willing to say publicly about why you chose not to?
I would say that ultimately we thought that the quickest, most efficient way to resolve this question was to try to have the Supreme Court decide it as an original matter.
Even though the Supreme Court never takes such cases except in the classical context of like water or border disputes.
We looked at Maryland v. Louisiana, which is a case I think that you mentioned in your paper,
Yeah.
or in your paper, which to us seemed to recognize a right of action to bring a preemption case from one state against another. I mean, they never squarely addressed the issue of the case, but they took the case.
No, I'm not. I'm not critiquing the claim, right? What I'm suggesting was that perhaps part of why another state in your position might not have thought that the right answer was to sue the federal government, was some of the issues we've been talking about in this very panel, right? And that therefore the alternative was to go directly against the states, which actually might be the better alternative in that context.
Yes. That was our ultimate conclusion. We thought that, because we thought that the merits of the preemption argument, that this Controlled Substances Act clearly preempts what
Gonzales
Colorado
be
is
right.
doing. Yeah, if we can just get there, it's a clear winner. Whereas an attack, a lawsuit against the federal government begins, you get it, it's the immigration case, but maybe with slightly tougher facts as you get into sort of prosecutorial discretion, enforcement priorities, et cetera, et cetera. So.
Just as a question, if you wanted to make a similar complaint simply about medical marijuana, where Congress has had a role in actually approving the variation from pre-existing law,
We specifically excluded that from our claims for that. That's just a much tougher claim, because Congress has done so much to sort of contemplate medical marijuana regimes.
Okay, well, I'm going to try to keep the train running on time, and my watch tells me it's 9:29. So unless somebody has a 1-minute question they want to ask. Okay, well, thank you.
Wait,
all right, you got 1 minute. No, I'm just kidding.
This is for Patrick. Question is, after Massachusetts versus EPA, has that changed how your office thinks about what cases to bring and whether you try to bring more cases, and if so, what kind?
No, I mean, Massachusetts v. EPA, I think strikes people as a tough case because no one really believes that Massachusetts sued because they were worried about the loss of 6 inches of coastline, even though that's ultimately how the court resolved the case. It's also a little bit of a strange case. I think special solicitude, I've always understood special solicitude to mean that we should take a broader view of what constitutes an injury in fact with respect to states. The states can be injured in ways that no one else can be. But you read the case, and that potential loss of coastline really didn't seem imminent. And there was traceability and redressability issues. So it seemed as though the court was using special solicitude as we're going to relax those requirements with respect to state. And that strikes all of us, I think, as wrong.
I mean, there's also an argument that the special solicitude language stems from an era where original jurisdiction litigation was more frequent.
Yeah.
And where across multiple doctrines, the court was actually willing to forgive procedural improprieties in its original docket in ways that it wouldn't in appellate cases.
Right. So I would say that I invoke special solicitude in virtually every case, but I usually invoke it just to say you should recognize that we can be unique in sort of unique sovereign ways. A lot of things that Shannon talks about. Also, though, Mass v. EPA was a tough case because we always recognize that like mandatory injunctions are disfavored versus prohibitory. I think that was a tough case because you're always in a tougher spot when you're trying to ask a court to engage in the business of telling the executive branch what to do. Whereas in most of the cases we bring, we're asking for them to prevent the federal government from doing something where the remedy is revert to the status quo, which I think courts have a lot less trouble, sort of political question and those sorts of notions aren't nearly as involved. So.
Good point. Okay, well, thank you very much for coming out today. Thank our speakers.